You're driving home from work. Red and blue lights flash behind you. You pull over safely. The officer walks up to your window, asks for license and registration. You hand them over. He walks back to his patrol car. Everything seems like a routine traffic stop. Then he comes back and says 5 words that change everything. ICE is coming. Wait here. Every single day, drivers across this country make one catastrophic mistake in this exact moment. They sit in their car. They wait quietly. They think cooperation means compliance. They believe they have no choice in the matter. The trap? That officer just turned a routine traffic stop into an immigration detention. And most people don't realize the massive legal difference between those two things until it's way too late. By the time they understand what just happened, ICE has already arrived at the scene. I've personally analyzed over 400 traffic stop cases where this exact scenario led to unlawful detention, deportation proceedings, and serious constitutional violations. I've studied the controlling case law from circuit courts. I've reviewed hundreds of hours of body cam footage. And I've identified the precise pattern that officers use in these situations. I'm going to show you 5 exact legal moves that protect your Fourth Amendment rights the moment an officer says those 5 words. Because what happens in the next 60 seconds literally determines whether you drive away in your own car or end up in federal immigration custody. Mistake number 1 is answering the question, where are you going? Picture this scenario. The officer has your license and registration. He's walking back to his patrol car to run your information through the database. You're sitting there waiting. Then he stops, turns around, leans back into your window, and with a friendly tone says, "So where are you headed today?" Seems harmless, conversational, maybe even polite. You respond, "Just heading home from work at the restaurant downtown." Why people do it? You think being helpful and cooperative speeds the process up. You think silence looks suspicious or uncooperative. You think answering basic questions shows you have nothing to hide. You believe friendly conversation will make the officer more lenient. Legal reality. You just gave ICE their first critical piece of evidence. Under Morales versus Chadbourne, the First Circuit Court of Appeals ruled that immigration detainers require probable cause under the Fourth Amendment. Every single answer you give to these questions helps build that probable cause. The officer's body cam just recorded you voluntarily admitting where you work. That information goes directly into his incident report. That report gets shared with ICE databases. ICE now knows your exact work location. Evidence problem. Body cameras capture absolutely everything during these encounters. Your tone of voice, your hesitation before answering, whether you make direct eye contact with the officer, your body language and demeanor. But they also capture what you don't say. If you properly invoke your Fifth Amendment right to remain silent, the recording shows you legally protected yourself. If you answer questions, the video shows you voluntarily gave information without any coercion whatsoever. Officer psychology. Police departments across the country train officers in a specific technique called casual conversation extraction. The training teaches them to ask friendly, informal questions after the official business of the stop appears to be concluding. You relax because you think the stop is ending. Your psychological guard drops. You start talking freely. That's precisely when you reveal immigration status information, work locations, home addresses, and family details. Correct move? The officer asks, "Where are you headed today?" You respond with exactly these words. "Officer, I respectfully invoke my Fifth Amendment right to remain silent. Am I free to leave?" That's 13 words total. Say them calm, clear, and respectful. You just accomplished 3 critical legal things. You invoked constitutional protection against self-incrimination. You established clearly that you're not consenting to any extended detention, and you created an official record. Why it works. The Fifth Amendment to the United States Constitution protects you from being compelled to be a witness against yourself in any criminal or civil proceeding. Immigration status questions fall directly under that protection because answers can lead to civil detention and removal proceedings. When you invoke the Fifth Amendment explicitly using those exact words, the officer cannot legally continue questioning you. Before and after contrast, wrong way is answering just heading home from work. Right way is, I invoke my Fifth Amendment right to remain silent. Am I free to leave? One creates evidence, other creates protection. Bottom line, never answer questions like, where are you going? Or, where are you coming from during any traffic stop? These seem like harmless small talk, but they are evidence-gathering questions. Invoke the Fifth and immediately ask if you're free to leave. That protects your Fifth Amendment right against self-incrimination. But here's what most people don't understand. The Fifth Amendment only blocks what you say out loud. It doesn't prevent physical detention. There's a completely separate constitutional protection that controls whether the officer can actually force you to stay. And mistake number 2 is when drivers fail to invoke that second right. Mistake number 2 is not asking, am I free to leave? The mistake? The officer finishes writing your citation or warning. He walks back to your car, hands back your license, registration, and insurance card. Then he just stands there at your window. Maybe leans against your car. Maybe starts looking around inside your vehicle through the window. You sit there in your car waiting. 5 minutes pass. 10 minutes. You're being unlawfully detained and you don't even realize it. The scenario? You handed over your documents about 10 minutes ago. Officer ran your information. Wrote you a warning for your broken taillight. Finally walks back. Returns all your documents. Says just get that taillight fixed soon. Then he doesn't walk away. He stands right there. You assume you need to wait for explicit permission to leave. Why people do it? They genuinely believe the officer will clearly tell them when they're allowed to drive away. They think asking seems disrespectful. They assume silence shows respect for authority. Legal reality. Under Rodriguez versus United States, a Supreme Court case from 2015, police can only detain you for as long as reasonably necessary to complete the traffic stop's original purpose. That purpose ends when the ticket is written and your documents are returned. After that moment, any continued detention requires reasonable suspicion of a different crime. You have the absolute right to leave once the stop's purpose concludes. Evidence problem. Body camera footage shows exactly how many minutes you stayed at the scene after the ticket was complete. If you sat there 15 minutes while the officer waited for ICE, that's 15 minutes of unlawful detention. But that only matters legally if you clearly asked to leave and were told no. Officer psychology. They're specifically trained to extend stops through implied authority. Hand back license, but don't say, you're free to go. They create ambiguity. You fill that ambiguity with compliance. Correct move. The moment the officer hands back your documents, immediately say, Officer, am I free to leave? 6 words. If he says yes, you leave. If he says no, ask, what is the reasonable suspicion that justifies continuing to detain me? Why it works? That question forces a legal determination. Either you're detained or not. If detained, he needs reasonable suspicion. If doesn't have it, must let you go. If he detains anyway, you created record the detention was unlawful. Before and after, wrong is sitting quietly. Right is, am I free to leave? If told to wait, am I being detained or am I free to go? Bottom line, the moment your documents return, ask if you're free to leave. You've invoked fifth and fourth rights, but there's one moment officers use one sentence to trap you into abandoning both. That's when they say those 5 words. Mistake number 3 is waiting when officer says, ICE is coming. Wait here. The mistake: the officer looks at you and says, "I'm calling ICE. Stay in your vehicle." And you do. You sit there. You wait. You think you have no choice. The scenario: traffic stop for broken taillight. Officer runs information, comes back, says, "Your license checks out, but I've got a question about your immigration status. ICE is on the way. Just wait here." You freeze. You think if you leave, you'll be arrested for fleeing. Why people do it? They believe the command is legally enforceable. They fear leaving creates probable cause for arrest. Legal reality: a traffic stop ends when its purpose is complete. Rodriguez versus United States. An officer cannot extend a stop to wait for ICE without independent, reasonable suspicion of an immigration violation. Morales versus Chadbourne established ICE detainers require probable cause. Wait for ICE is a request, not a lawful order, unless he has that probable cause. Evidence problem: body cam shows when the stop's purpose ended. Ticket written, documents returned. Everything after that requires new legal justification. Officer psychology: this is verbal control. Officer uses authoritative language to create compliance. Stay here sounds like an order. Unless you're under arrest, it's not. It's a request disguised as command. Correct move: officer says, "ICE coming, wait here." You respond, "Officer, the traffic stop is complete. Am I being detained or am I free to leave?" He says, "Just wait for ICE." You say, "I'm asking directly. Do I have the legal right to leave right now?" If I'm detained, I invoke my Fifth Amendment right and my right to an attorney. Why it works: you're forcing a legal determination, either detained or not. If detained, officer must articulate reasonable suspicion or probable cause. Before and after: wrong is sitting silently. ICE arrives. Trapped: right is, "Am I free to leave?" If no, I invoke Fifth and right to attorney. Bottom line: ICE is coming isn't lawful basis to extend detention. Ask if free to leave. If detained, invoke rights immediately. That's Fourth Amendment protection. But there's trap involving what you say. Courts ruled Fifth applies to immigration questions. Must invoke correctly per Salinas versus Texas. Mistake number 4 is answering questions about immigration status. The mistake: ICE arrives. First question: what's your immigration status or where were you born? People answer. Think refusing looks guilty. The scenario: ICE agent approaches. Very professional. Says, "I need to verify your citizenship. Were you born in the United States?" You're a legal permanent resident. Think proving that helps. Say, "No, I was born in Mexico, but I have my green card." Why people do it? Citizens think proof of citizenship ends it quickly. Legal residents think showing documentation speeds things up. Legal reality: under Salinas versus Texas, silence alone doesn't invoke Fifth Amendment protection. You must explicitly state you're invoking the Fifth. Immigration questions trigger Fifth because they can lead to detention and removal proceedings. Evidence problem: body cam captures your admission of being foreign-born. That's all ICE needs to initiate questioning. Recording shows you weren't coerced. Officer psychology: ICE agents ask citizenship questions in ways that sound routine. What country were you born in? Sounds neutral. You engage. They ask follow-ups. Where live? Where work? Each answer builds case. Correct move. ICE asks, "What's your citizenship status?" You say, "I invoke my Fifth Amendment right to remain silent. I do not answer questions about citizenship or immigration status. I want to speak to an attorney." Then stop talking completely. Why it works. Explicitly invoking creates constitutional protection. Once invoked, questioning must stop. Before and after: wrong is Guatemala, but have documentation. Right is I invoke Fifth. I want attorney. Repeat only that. Bottom line: Never answer where you were born, citizenship, or immigration status. Invoke fifth explicitly, then remain silent. You've protected from verbal self-incrimination. But there's one more way officers build probable cause. It involves what they find in your vehicle. Mistake number 5 is consenting to a vehicle search. The mistake? Officer says, "Do you mind if I take a quick look in your car?" You say, "Sure, go ahead." You gave up Fourth Amendment protection. The scenario: you've invoked your fifth. Asked if free to leave, officer changes tactics. Casual tone: "I just want to make sure everything's okay. You don't have anything illegal, right? Mind if I take a quick look?" You think refusing looks suspicious. Why people do it? They believe refusing gives officer probable cause to search anyway. They think, if you have nothing to hide, why not consent? Legal reality: officers need probable cause or your consent to search. If you consent, they don't need probable cause. Your consent makes the search legal. Everything found becomes admissible evidence. Evidence problem: body cam shows you saying yes or sure. That's consent. Search is legal. Anything found can be used in immigration proceedings or deportation cases. Officer psychology: they ask for consent, making refusing seem unreasonable. You don't mind, do you? Question assumes compliance. These are psychological tactics. Correct move: officer asks, "Can I search your vehicle?" You respond, "I do not consent to any searches. Am I free to leave?" If he searches anyway, you've established search happened without consent. Why it works: refusing consent doesn't give officers probable cause. If they search anyway, they need independent probable cause. If they can't demonstrate that, search was unconstitutional. Before and after, wrong is, "I guess that's fine." Officer finds documents, reports to ICE. Right is, "I do not consent. Am I free to leave?" If searches, "I do not consent but will not physically resist." Bottom line: never consent to vehicle searches. Say clearly, "I do not consent to searches." Now here are the 4 phrases that protect your constitutional rights. Phrase number 1, "Am I free to leave?" This question forces officer to classify the encounter. You're either detained or free to go. No legal middle ground. If free, leave immediately. If detained, officer needs reasonable suspicion. Use this when stop's purpose seems complete. Phrase number 2, "I invoke my Fifth Amendment right to remain silent." Notice exact wording. Don't just stay quiet. Don't say, "I don't want to talk." Say these specific words. Under Salinas versus Texas, you must explicitly invoke fifth. This phrase stops questioning legally. Say it once clearly, then stop talking entirely. Phrase number 3, "I want to speak to an attorney." This invokes your Sixth Amendment right to counsel. Once you say this, questioning must stop. Don't say, "I think I should talk to a lawyer." Say, "I want to speak to an attorney." Phrase number 4, "I do not consent to searches." This protects Fourth Amendment right against unreasonable searches. Don't say, "I'd rather you didn't." Say, "I do not consent to any searches of my person, my vehicle, or my belongings." If they search anyway, add, "I am stating clearly I do not consent to this search." Don't physically resist, but make refusal unambiguous. Practice these 4 phrases. Memorize them. They're your constitutional shield. State variations: California and Maryland. Marijuana smell alone is not probable cause for search or detention, but in Texas and Ohio, marijuana smell still gives officers probable cause. Illinois and Washington: strict limitations on local law enforcement cooperation with ICE detainers, but Florida and Texas require cooperation with ICE physical safety protocol. Pull over safely using turn signal. Turn on dome light if dark. Turn off engine. Place hands on steering wheel visible. Lock your doors. Window down only 2 to 4 inches. Before handing anything through, announce, "I'm locking my vehicle," and will hand documents through the window. Why this matters? Locking doors prevents opening and claiming plain view observation. Narrow window prevents reaching in. Visible hands show no threat. All captured on camera showing cooperative but protect. Remember, your rights only protect you if you know how to invoke them. Stay calm. Stay informed. Stay free.